Good morning, everybody. Welcome to the post-apocalyptic asset protection seminar today. Glad we don't have over 50 people. There's good and bad in all this, I guess.
Yeah.
Today is the final portion of a four-part series on wills, estates, trusts, and asset protection. Today, we're going to talk about asset protection, so thanks for joining us. All right. Asset protection really is nothing more than utilizing the appropriately structured techniques to legally protect your assets from creditors or from civil judgments. The goal is simple. Structure your business, structure your assets in a manner which gives you full use and benefit of them, but at the same time protecting those assets. So and of course a lot of people don't remember, anyone remember Nelson Rockefeller? Okay, from your state. Okay, actually 41st vice president. Remember, he was vice president when Nixon resigned and Ford, so he became the vice president for I think 3 years during that time period. But Nelson Rockefeller of the Rockefeller Standard Oil Company, he was famous for those issues because his father was the richest person in the world at one time, and he said the secret to success is owning nothing but controlling everything. And that's in essence what asset protection is. You want to be judgment proof. You want to step back. If someone sues you, not be concerned about that, but you want to have access and control of all the assets. So, life happens. We didn't expect what's going on right now. We have to be prepared. Unexpected liability can come from just about anywhere, both internal and external. I mean, both within a company and both external being sued by someone on the outside. It's estimated that 40 million lawsuits are filed every year in the United States. 40 million. Guys in my profession, we have to stay busy. Idle hands are the work of the devil, apparently. But in this case, we found out that non-idle hands might be the work of the devil also. We all remember, the lawsuit of the McDonald's where the woman put the cup in her lap.
Yes.
Unfortunately, her crotch got burned to a tune of about $3 million for the jury verdict. That was later overturned to around $650,000. But it just goes to show what can happen when you least expect it. You have to be careful of that. And of course, this is indicative of my profession. The legal disclaimers everywhere. Well, of course, this is based upon the McDonald's, but McDonald's is not responsible for your happiness because he's having a happy meal. I mean, we've all seen the hair dryers. Don't use this while you're taking a shower. I mean, iron is hot. Don't iron your hand. Ridiculous, but lawsuits do happen. And that is the reason for these ridiculous disclaimers. So let's talk about asset protection and what we can do. So there's potential liability everywhere, like we talked about, both internal and external. IRS and other tax authorities, automobile accidents, victims claiming injuries either at work or at home, unanticipated medical billings. You go to the hospital with a virus today. What's going to happen and what's the standard hospital cost? It's about $10,000 per day is the average hospital bill here in the United States for an inpatient. And that's not counting ICU, that's not counting medication. And of course, credit card companies. You can get over exuberant, spend those credit cards, have a great happy Christmas, or in the event, good morning, come on in. Or in the event, you have issues with such things as loss of employment, divorce, medical issues. Those are the primary factors in filing bankruptcy. 97% of all bankruptcies are caused because of medical, loss of employment, or divorce. So there are ways to plan and strategize and protect your assets under those circumstances. Other issues, business creditors, insulating you and your business against external creditors and again, internal creditors. Creditors or other individuals where you co-signed or guaranteed a loan. Never guarantee a loan. Try not to obligate yourself on a contingent liability when, of course, you're relying upon someone else and someone else's well-being, economic insulation to be able to pay the debt. If not, you're responsible. And of course, having appropriate asset protection measures for marital or live-in situations. There are, in fact, ways that a parent can structure certain distributions to a kid or family member and ensure that it only goes to the kid or family member in the event that they get divorced or they're in an unsavory family situation. Instances such as a family limited partnership can transfer assets to kids, assets to family members, and ensure that the spouse does not receive those assets. We'll talk a little bit about that today. Now, things to consider. Asset protection measures must be put in place before a liability arises. In Florida, we have issues with regard to fraudulent transfer issues. And again, we'll talk about that. But if you don't have these measures in place prior to the potential liability, there's a great potential that it's going to be set aside and called a fraudulent transfer. Now, once a lawsuit is filed, there's only minor steps that we can take to try to assist in mitigating the loss of liability. So have these structures into place and always be forward thinking. Always be looking at what's going on around you, your assets, your income, your debts, your liability, contingent liabilities, and you can always plan around them. And that's what we're going to look at. Now, we talked about fraudulent transfers. In Florida, we have a statute, which is 222.304 or 0.30, and that says if you try to adjust or protect your assets after a situation or incident took place, it can be set aside if that occurred within 4 years of the transfer. So, you think you planned properly, but if something occurs, let's say you had a contingent you co-signed something for your kid, and your kid defaults on the obligation, guess what? They can come after you because you're a personal guarantor in those obligations. But if you set some of these techniques and measures in place several years prior and planned ahead, then they still can't touch your assets. But if they see that you did something to avoid payment of creditors, there's a 4-year statute of limitations for them to reach back into your pocket and call it a fraudulent transfer. So make sure your asset protection plans are done for legitimate business or estate planning purposes. Now, you can still do some things within that time period because that 4-year time period, what they're going to look at is your intent. So maybe you were a co-signer on an obligation and they were in force, they were making timely payments, you did proper estate planning, you did proper asset protection planning. If those are in place, they can't show that you did this intentionally to evade or have a fraudulent intent in dealing with creditors. So again, it has to serve a legitimate purpose, and you need to document these things because they're going to look at your intent. So what do we do here? We plot, we plan, we strategize. We take a look at the entire picture of everything, and then we try to structure it looking forward into potential pitfalls or obligations. The goal is to keep assets out of the reach of these potential creditors. And there's lots of easy, beneficial ways to do that. And that's what we're going to talk about right now, is we're going to talk about basic exemptions. Now, these are designed for residents of the state of Florida, okay? I'm sure there are similar statutes in every state. Of course, they vary based upon value or exemptions, but typically across the board, you'll find exemptions like this. So let's run down and talk about the basics exemptions. These are assets which are exempt from creditors' claims. So even if you get a huge judgment against you for a car accident or something like that, if your assets are structured in these manners, creditors cannot touch it. According to Florida Statute 222, 100% of an IRA, 401k, pension profit sharing, cash value to life insurance, and annuities are all exempt from creditors' claims. So even if you have a huge judgment, they can't touch these assets. These assets are not able to be in any way levied against by your creditor. $1,000 personal property exemption. That doesn't go very far, but it's $1,000. $1,000 vehicle exemption. Now you'll also see that Florida Statute 222 has lots of other specialty exemptions. There's government exemptions. There's railroad exemptions. There's Social Security disability. There's governmental benefits. These income, pensions, or other benefits are outlined in the statute, much like a laundry list, and it'll tell you what is exempt from creditor claims or attachments. So if you, for instance, take your assets and you maximize your $13,000 per year per couple in your IRA, that's going to be protected. If you do that with an annuity, that's going to be protected. Regardless of what happens externally, those assets are going to be protected from creditors' claims. So let's talk about another couple assets. In Florida, we have homestead. Most states have some sort of a homestead law. In Florida, we have what's called constitutional homestead. It's Article 10, Section 4 of the Florida Constitution, and it says if you make a property your place of residence or abode, your primary residence, and it's up to 1/2 of an acre in a municipality, up to 160 acres outside of a municipality, and that's your home, that's your residence, then that is exempt from creditors' claims.
Really?
So no one can touch your assets, with the exception of your mortgage, real estate taxes, and certain mechanics liens. Now, mechanics liens are, for instance, someone puts an air conditioner on your property and files a notice to owner standard type of lien. If you don't pay and they file a lien, they have about 1 year to foreclose. But aside from that, your home is 100% protected. In fact, I don't know, we're all of that age where we remember, you remember Paul Brazilian? He was a corporate raider way back in the 80s.
Yeah.
He bought the Singer Corporation, a lot of others. Well, this gentleman, you know, the reason I bring him up is because he ended up filing bankruptcy here in the Middle District of Florida. Years back, he filed 6 or 8 bankruptcies. And he actually moved to Florida specifically for the purpose of creating a homestead exemption. And he bought this $12 or $15 million house outside of Tampa to park some of his assets. And creditors tried to set that aside. But Florida is extremely stringent on protecting the homestead exemption for the individual. In fact, everyone heard, years back, O.J. Simpson, he moved to Florida. He acquired residency down in the Miami area for the purpose of protecting homestead. So these folks are taking a big chunk of assets and they're moving it down to Florida to take advantage of this homestead asset protection. There is some case law. Again, it looks at intent. There was some case law previously where a gentleman, Ohio, Illinois, or something up there, moved down to Florida with a specific intent of buying homestead property, parking, and exempting assets. But, he apparently told some individuals that this was his purpose and his reason for the move because there was a pending lawsuit. Now, again, it's about intent. Very rarely does the court set exemptions to allow the creditor to invade the homestead exemption statute. So you just have to have the right intent. But again, homestead exempts 100% of the homestead value of that property. Now, we can, and you should, protect assets that are beyond these basic exemptions. First off, take a look at your assets, earnings, and income, and again, make sure you structure it in the appropriate manner. But beyond that, the number one way of wealth in the United States is having your own business or a small business and creating wealth as a business owner. So when we look beyond those basic exemptions, we use tools and techniques such as limited liability companies, family limited partnerships, corporations, land trust, or other trust. Now let's talk about each one of those and how they work. A limited liability company is just that. It's an LLC. Limited liability companies allow you as the owner of the company to exercise dominion and control over this entity. And it limits your liability only to the value of the asset itself. So it doesn't allow external exposure. It's contained within this entity. So if the entity consists of real estate and a business and accounts receivable, If you're sued, the creditor can only get those assets within the entity. It doesn't go to your personal assets. Now, we have to be careful in Florida. We'll talk about it on another slide about using single member LLCs. But LLC is a perfect vehicle to utilize in different structures in asset protection. Family limited partnerships. These type of entities are fantastic. Remember Sam Walton. Sam Walton used a family limited partnership to, at the time of his death, pass $40 billion to his family members with very limited tax consequences, and allowed him to structure it so that the family could control it over time and could transfer these estate planning efficiently. Family limited partnerships does exactly what Nelson Rockefeller talked about. It allows you to control the asset with very little ownership and exposure, but at the same time, the ownership is structured within the limited partners. So what you do with a family limited partnership, you have limited partners and you have general partners. The limited partners have certain rights. The general partners have the rights to operate and control. The general partners may only have a 1 or 2 or 3% ownership interest in the company, but the limited partners have all the assets. The general partner has all the control and value. But as a general partner, you still control it all. Excellent vehicle to utilize depending upon your circumstances. Corporations, again, corporations are fantastic. They limit the liability to the entity itself, but folks say, hey, if I have a corporation, aren't I taxed twice? You're taxed at the corporate level, then you're taxed at the individual level. Well, that is true to a point, but you're not structuring it properly. It depends upon your draws, disbursement, and how you have things structured in the company. Tax consequences and payment arrangements by utilizing both a corporation along with a limited liability uses or results in fantastic ability to be able to control taxes, plus at the same time be able to control and protect the entity itself. Now, land trusts. You've probably heard about land trusts. Let me clear out some misnomers regarding this issue. A land trust is an entity that really provides anonymity. It doesn't really provide a lot of asset protection. You typically use those entities in conjunction with something else to provide asset protection. For instance, if you want to buy, well, let's talk about the big Orlando entity, Disney. What did Disney utilize to be able to buy and accumulate all that property? Land trusts. So they went in with LLCs and land trusts and they bought all this up. No one really knew who was buying all these hundreds and hundreds of thousands of acres, because what a land trust is, it's a trust that has two parties. It has a beneficial owner, which might be you and I, and it has a trustee. And the trustee might be, John Blow attorney. The trustee is the only person that any individual will see. It's the only person that appears in public records and contracts and documents. So everything is done under the land trust name, but the real beneficial, the person who operates it and owns it, is the beneficial owner. So, but it really doesn't provide any limited liability or other protection, but it certainly provides anonymity. You're looking to buy a property, or you're looking to hide your name, or you've got a crazy ex-spouse out there, So utilizing a land trust allows you to maintain some anonymity. Other trusts, there's lots of other trusts. There's irrevocable trust, there's spendthrift trust, there's Q-tip trust. Lots of other trusts can be utilized to protect assets, to pass assets, and to ensure that there's a clean transfer between heirs and beneficiaries. Now, this is not really an asset protection tool, but I think it's something that's vitally important because I think it's a moral and ethical obligation also, and it is an asset protection tool. It's insurance. So don't forget insurance. If you're involved in an accident and you hurt someone, accidents happen. I mean, you want to ensure that the person is compensated. You want to, redress your damages and loss. So insurance can certainly pay the person who has an injury to ensure that they don't go after your personal assets. So insurance can certainly be utilized to a great benefit. It not only protects the assets, but it provides recourse for someone who's trying to sue you. Now, umbrella policies, I don't know how many have umbrella policies. Umbrella policies are great because they cover a lot of different realms, not just the car or the house. They cover a lot of different obligations, but umbrella policies are tough. Just make sure that you read it over and understand exactly what's included within the umbrella policy, because insurance companies' jobs are to take in premiums and not pay out on claims. So you're actually fighting against your own company to cover your butt. But that's what asset protection does. So limited liability companies. Now, I talked previously about certain things we have to be careful of with limited liability companies in Florida. Now, limited liability companies, the creditor of a member, let's say Karen, let's say you and I have a limited liability company, and we each own 50% of the company. Now, she has an external claim. Let's say she runs over her friend Laura while riding a bike, and Laura breaks her ankle, and she sues Karen. Well, if that occurs, that's an external liability claim. It's not something that occurred within the company. But if Laura sues her, and I'll represent you whenever you need to. If Laura sues, after I prepare her asset protection, I'm going to be running circles around here. So if Laura sues Karen and gets a judgment against her, that's great. She's perfected her judgment, but she just has a judgment. She has to collect on her judgment. Well, guess what? Karen's membership share or interest in the limited liability company is an asset which Laura can get. She can levy against her 50%. But on circumstances like that, all the creditor would get is going to be what's called a charging order. A charging order means that, Laura, you have the right to get any income distributions that might be going to Karen's 50%. So if we make $1 million a year, you can take Karen's $500,000 as with that charging order. But one of the beauties about an LLC is Karen and I would still control the LLC. We control how it's structured. Guess what? Next year, we're sorry, Laura, we're not doing any income distributions. So you're not going to get the right to that income distribution. But guess what also? Unfortunately, the corporation is taxed for her 50%. So you exercise your charging order, you won't even get any money, but you'll also get a bill from the IRS on your share of that 50%, which went undistributed. So suddenly that $500,000 that you were going to get, 82 cents will settle it for you. But Karen still needs money though, doesn't she? She does. I've seen her shoes. She has habits. So Karen, we're not doing income distributions this year, but would you like a loan from the company?
Yes.
The company will loan you some money. Guess what? That's a loan. It's not income. So she has the full use and benefit of the LLC. She has all the assets, but you get billed. So see, the way you structure things, the way you use things makes a huge benefit. Now, beware, Florida has a law with regard to single member LLCs. A single member LLC is just me. If I'm the sole person, I'm the sole member of the LLC, it's not going to really limit my liability, because the Florida Supreme Court case years back on Olmstead said, hey, you're really just an alter ego of the same person. So if you don't declare distributions, you're really within the same realm. You're not protecting multiple parties. So in Florida, you need to do a multi-member LLC or structured in another manner. And there's lots of things you can do by still having a single member LLC. We can create a different partnership and structure where your partnership can own one, you can own the other. I mean, there are lots of ways to structure it, but it has to be done appropriately and timely.
May I ask, what about husband-wife LLC in Florida? Is that considered
It depends upon how you write the stock. If you each have different membership interests, it's a multi-member LLC. If you own or have it as tenancy by the entirety as one entity, that's included, that is considered a one-person entity. So it's how you have the stock structure. Well, in this case, membership shares or units.
Right.
Stock is with a corporation, membership interest or units is an LLC. So there are ways around that. Now, and I just said Florida, lots of states have something like this, but then again, there's lots of states that have jurisdictional issues that allow for more or greater asset protection, such as Alaska, such as Wyoming, such as Delaware and Nevada. They all have operations where you can have privacy and confidentiality and single member LLCs. In those states, you do have the benefit of using what's called a nominee, much like a land trust. All the person would do is look in public records. All they can see is who the nominee is. They're not even going to know that you own the shares of stock or you control everything. So, depending upon what you're looking to do, that will determine the type of vehicle that you use to, that's your GPS to appropriate asset protection, is knowing what your goal is and then structuring and navigating it the proper way. So what do we consider when we take a look at asset protection? We take a look at your assets, the type of assets, the ownership, the value, the encumbrance, what you intend to do with your assets. So we utilize those basic asset protection tools under 222, IRA, 401k, etc. We ensure that all of those are properly structured, that you're aware of those benefits, because those are time-tested asset protection measures. If you're within those entities, within that structure, you should be fine. We then take a look at your income, and we try to determine, okay, where's your income coming in? Through what vehicle? Can we change that income around to where it's being paid to a different entity? Is it being paid to a spouse? Is it being paid as part of a payoff or liability? Is there a way to protect and preserve the income and ensure that you not only get the use of the income, but you also protect it at the same time? And then finally, we've got to take at the liabilities. So is it secured debt? Is it unsecured debt? Is it contingent liability? So if we explore and discuss all of those issues, we then can devise a strategy and plan to help you analyze how to properly protect your assets within the arena of the type of assets and what your goals are you're looking to resolve. So let's talk about a standard business owner. This is utilizing a C Corp, and you can also utilize, of course, an LLC. But in essence, you're the business owner, and you're certainly looking to protect your personal assets. So asset protection-wise, personally, you'll use those vehicles. By the way, a revocable trust is an estate planning tool. It's not an asset protection tool. It is useful in a lot of different ways, but don't confuse an estate planning inter vivos trust. Don't consider that an asset protection tool. It's not, okay? There are other vehicles around that. So you have your business assets here, and this is typically an LLC or a C Corp. And this line here is what you're trying to protect. So beyond the line here, creditors can only reach the business assets. We know that. So as long as you treat your business as a business, properly incorporated, paying your annual dues, not dipping into the company inkwell, not treating it as your personal piggy bank, having your corporate meetings, having your corporate records, keeping your taxes properly, as long as you do everything in a business manner and format, the creditor is not going to pierce the corporate veil to get back into your personal assets. So creditors can only reach the business assets. But again, if you structure the business assets appropriately, you can also ensure that those business assets are protected also. So with this structure, creditors can only get in this arena. Now, let's go to the next slide, and let's talk about structuring it and protecting the business. So when you're talking about a business structure, There's lots of cool things that can be done. The goal is to transfer the risk to something else that has no assets. So if someone slips and falls at your condo complex, the condo is going to be looking to spread out the liability and try to ensure that someone else is co-responsible for the obligation. So, the things we have to be concerned with is the inventory, the accounts receivables, and the assets of the company. So you can spin this off into different companies with different duties and obligations and liabilities. So for instance, it represented a company that owned a concrete manufacturing business. So they not only manufacture the concrete, but they own the land, they own the equipment, and they own the trucking. So if you had just one corporation, if a truck had an accident, guess what? That entire corporation is going to go down if they don't have sufficient asset, if they don't have sufficient insurance. So what you do is you structure it in multiple companies, multiple LLCs. You put in place lease or management agreements so that the trucking company is a separate company. Anything involving trucking liability stays with that company. The land company, again, anything that occurs on the property is limited to the land. Leasing company, say you have a management company that cleans the property of your condominium complex. You're going to bring them and their liability in because someone slipped. And they slipped because the management company or the maintenance company didn't properly clean the grease trap or didn't clean something up and they slipped. So you can structure it by, again, creating a limited partnership, having a general partner who owns and controls everything, only have 1%. Limited partners have 99%. They may own the land and building, and the equipment is separate. What you're doing is you're separating the risk and the assets, liability and responsibility. And this is all that asset protection does, is analyzes your assets, your liability, and structures ways to insulate it within a certain part. Are we going to have risk in business? Yes. That's what business is. It's risk. It's analyzing, adopting, and controlling the risk. But if you can insulate it to one part of it, you can protect your assets while the rest of it flourish. And of course, insurance. Now, so let's put all these pieces together. Over the last 4 weeks, we talked about medical and health issues. Tough time going on right now in this country with health and medical issues. So if you want to take a look, you can go to our YouTube station and Rants, I'm a bad attorney, and you'll see we did a seminar on healthcare and medical issues, healthcare surrogate, durable powers of attorney, living wills. Those are all contained in that seminar. Estate planning issues, how to transfer your assets, how to avoid probate, and today, how to protect your assets. And what we have done is, I'm trying to be smart here. Hope it helps. We created something called the Organized Life Workbook. Now, this is a workbook which is divided into multiple sections. There's actually 19 different sections, which allows people to get all of their information and documentation in one place, ready and available. I know we're all private, and we should be. We should ensure there's confidentiality. No one discusses, at least our age and generation, we don't discuss income and finances with our kids and family. There may be a general understanding, but the specifics, we don't want them to know, and we don't think they should know. This workbook here provides basic information as to the various arenas, business interest, liabilities, assets, keys, codes, alarms, pet trusts, estate planning. Everything is in here with little checklists and little information sheet where you can write all this information in there. So what you'll see is this is divided, and this is designed for your own personal use to be able to store all this information in a manner that's easily available to the kids. So if you have a medical issue or a stroke, kids can pull it off the shelf, and they know exactly who your doctor is. They know exactly what medications you're on. They know exactly where your will is because it's in here. They know exactly who to call and contact regarding looking up your broker, your doctor, where your safety deposit box might be. All the information is here, ready and available. You complete this if you want to. If you don't want to, and you have all the documents with it, that's fine too. But you're really just making it easy for your family to have everything organized and existing and available for the family. Now, when I deal with a family on a probate or other state, what do I get when I have a new meeting? I usually get a box, about a banker's box worth of paperwork. Nothing is organized, nothing is collated. They have no idea. Probably a third or more of the states that we do, we prepare the estate, we do the administration, and then 2 years later, we get a call from a family member that says, hey, I just found a life insurance policy, or hey, I just found this asset, stocks. What do I do with it? And my response is, well, you got to come back to me. We have to file a petition to reopen the estate. We have to do this all over again. So that workbook is designed to allow people to get all their information, documentation, all their plans, both medical, estate, business, and even has memorial plans for individuals planning their own funeral. Here's who I would like to be pallbearers, etc. All of that is contained on checklist where you can just complete it at your own time and in the privacy of your home. You don't have to share it with anyone. It's just there and available for the ease of the family. We typically sell those for $79 online and $29 if you want a flash drive with all the information or an email. But today, to our group, we're giving away free on your with your registration here. So just make sure you have your email address on there, and we'll email you a packet of it. And that's all our discussion today. Did you all have any questions or things you want to talk about?
Thank you.
Thank you. We're good. They turn off on that.
Here, you said you're from the United Kingdom?
Yes.
Any I'm not an attorney, I'm a real estate broker. Okay. Here's your thing, because I tell the Canadians this. Any document you have there is fine, but what you need here for my Canadians is healthcare. By the time you figure out where it is, and then they have to confirm that it's the real thing, it's a medical emergency. That's the only thing that you might need here.
Right. I know for sure. Right.
Thank you. And we are now citizens, so.
Oh, then you, okay.
Yeah, we were supposed to leave Saturday.
Oh,
Go
no.
to Wales to go hiking for 2 weeks.
Oh, I'm so sorry.
Yeah.
So it's totally off?
It's off until September, I guess. We just rescheduled.
Rescheduled, did you lose your?
No, I think we got Norwegian Air, they're just transferring over.
Right, so you don't pay any cost.
Well, there may be some small hotels on the trail. We're doing the open dike path.
Oh, okay.
So it's the trail that separates Wales from England.
Oh, right.
It kind of parallels the Cotswolds there.
Okay.
Wow. We learned so much.
Well, good.
Thank you very
Thomas.
much,
You're welcome.
especially about Florida. We're grateful we came on.
Oh,
We took your car.
this is where we're going to retire to, there's a reason.
There's specific things here.
Thank you. Alberta, shake your hand. That's right.
Thank you so much. You have that too, all prepared.
Minutes one, claim. I have no clue, if they go that way. Nope.
You're welcome.
Well, I
Thank
got
you.
my hand down, there's a little loose metal piece, but I don't want to do that, so. That's a board, this afternoon. So give me like-
I don't know how to get instruction.
So, but I'm good. I didn't know, Laura's here. You saw your kids, all right? They're in the daycare. Okay, all right, we're going back to the conduct. Thanks.
Thank you.
All right, Jim, I'm gonna hang up on you, okay?
Yes.
He does.
Thanks.